So I guess everyone here, the topic is death by complexity, the future of industrial relations and EBAs. So EBAs are basically, they're called enterprise bargaining agreement. So it's an agreement, say, to have a particular set of terms that apply to your employees and figure out how that person is paid. So I guess this is to start off the questions. Dominique, what is current environment for EBA approvals? How does it work? And for whom does it work for?
So I guess the current environment for enterprise agreements isn't particularly favourable, certainly from our perspective, from a business perspective. It's quite difficult to get an enterprise agreement through the Fair Work Commission, and also just depending on the size of the business that you have, the type of workforce that you have, working through to create an enterprise agreement that is going to be of benefit to your business moving forward, that you want to lock in for a certain period of time with wage increases and all those kinds of things, can be quite difficult, particularly in this economic environment. Additionally, if you are a workforce that has an employee union that is particularly active in your workforce, you might find it harder to do so.
Yeah, and I guess there was a recent case that came out, I think it was the 7th to be exact, which required employees to give evidence to their employees about understanding of the enterprise agreement, that it was genuinely agreed, and I think that's one key force. I'm not too sure.
That's right. So there is a case that has come out, which is One Key versus the CFMEU, and look, that genuinely agreed to test that you just described is something that we certainly support, in the sense that that's typically not the problem. In this particular case, this particular business was quite well known to have formed, for want of a better word, a bit of a dodgy deal, where the employees were being paid about 0.25% above the modern award, and this deal was done between 5 particular individuals, and the case obviously found that realistically you need to give genuine evidence about all of your employees, or the employees or the cohort that they're looking at genuinely understood the agreement that they would enter into. This is not something that happens regularly. The problem now with this particular case, and the spotlight being on this business, is that we are moving into an election. We have seen the ACTU and the Change the Rules campaign moving through, and one of the big things that they're really focused on, which could significantly change our Fair Work Act, certainly if we get a change of government, is the fact that they are going to look at having prescribed numbers of cohorts when you are bargaining, and also they want to look at licensing labour hire groups. So look, this is a whole big can of worms in terms of a case, but I'm sure the panel has other views on it.
Okay, so we've talked about the current climate for EBA approvals, which is, I guess, one of the points we're talking about today. Kristin, how are EBAs used historically by businesses?
Look, I'm sure there's people who could talk about them from much further back than I can, but certainly when I started practicing in this area, it used to be much easier to make agreements, and almost all of the clients that I dealt with had agreements. And you have to look at the industrial landscape 10 years ago, or before the Fair Work Act came in 2010, you had businesses that were operating under multiple awards, and if you operated interstate, you've got different awards in every state. So there was a little bit more incentive for employers to look at making enterprise agreements, really just to simplify 5 or 6 awards into one set of terms and conditions for everybody. There was also the ability under the previous legislation, under the Workplace Relations Act, to strip away a lot of penalty rates and significantly reduce your wages costs. And whilst that was very controversial, and different people will have different views on whether that should have ever been allowed or not, the point was that you could legally do that. And so a lot of businesses were able to make agreements that put them ahead of their competitors by not having to pay weekend penalty rates and overtime rates, etc. So the landscape now is very, very different in that you've gone from some 4,000 awards down to about 125-ish, something like that. And most businesses, I would say the vast majority of businesses are working under 1, 2, maybe 3 awards, not the 10, 12 that they used to. And some of the terms across those awards are a lot more standardised. So there's less incentive from a streamlining perspective or less need to make an enterprise agreement. And also the test for making an enterprise agreement is now significantly different. There's no more taking things away. It's you've got to show that everyone's not just on par, they're better off under this agreement than they would have been under the award. And we've seen in recent years that becoming an increasingly difficult hurdle to get past because of this line-by-line, employee-by-employee approach. And if one employee can show that they're not better off under your agreement, then it doesn't matter how much better off other people will be because your agreement won't pass the test. So I think the change in laws around enterprise agreements and just the way that the industrial landscape's working generally has meant that there's just, in my opinion, less incentive for businesses to make these agreements than there were in the past, particularly, as Dominique says, when it's taking so long to get these deals done and, you know, you're having meeting after meeting after meeting and disputes in the commission and it's taking up a lot of your management and operational time. You'd want to know that there was going to be some really significant benefit to you as an organisation if you were going to go through that process. And the reality is for many organisations, there simply isn't that benefit. And I see in the industries that I deal in, particularly aged care, the unions in that space have these template agreements, and I imagine it's the same in retail and any number of other industries, but these template agreements that there's nothing about tailoring this to the organisation or flexibilities for the organisation. It's let's just roll out our template agreement to as many businesses as possible. And particularly organisations that are a bit smaller and don't have the resources or the clout to stand up for themselves sort of get, going to use a controversial word here, but bullied into making these agreements. And once you're on the agreement making path and you've got one in place, it becomes very, very difficult to undo it later on. And certainly a lot of the work that I'm doing these days is clients come to me and say, oh, we want to make an agreement or we want to make a new agreement, replace our existing. And I go, whoa, well, let's just step back and go, why would you even do that? And maybe there's some other options available to you.
So next question is directed to Craig and then we'll kind of let it flow from there. What sort of businesses do you think still can benefit from an enterprise agreement? And I guess in that too, kind of explain what the Office of the Australian Small Business and Family Ombudsman does.
Yeah, so just a bit of a comment around small businesses and enterprise agreements. Not many of them are going to have them because of those difficulties. Well, hardly any of them will have them. And another little interesting thing when you think about this area is that Australia is quite unusual, Australia and New Zealand is quite unusual even having these enterprise agreements. Hopefully you've gotten a... This was handed out. It's around somewhere. Is that... Oh, it's down. It's right down the front. If we can send them around... This is our look at the area, and from the basis that small businesses are basically not using enterprise agreements, where enterprise agreements, or their own specially designed ones, when agreements apply, it's quite a complex area. And thinking a bit outside the square on that basis that, you know, Australia is a little bit unusual here, how can we rethink the whole area without having a whole realm of changes that necessarily have to be brought in. Our office looks after small business. So our definition of small business, though, is up to 100 employees. So we get right up into that medium sort of territory. And as I mentioned at the start there, it's assistance, so one-to-one sort of assistance, which can be working back into places like the Fair Work Ombudsman or elsewhere inside the system, but also advocacy. This paper sits inside our advocacy type stream where we're looking to actually bring about some fairly simple changes to make the system work better. And so when you get a chance, touting it too much, to work through this and have a bit of a read, it's pretty simple what we're saying it would be a good approach. One is just to create a tool that small businesses can use, and if they satisfy the tool after answering little questions and things inside it, then they're inside a safe harbour. So it tries to just do away with the complexity of the system. And the second part of this paper is a lot about making the system work for all businesses, including small businesses, so improving things like the education there, the understanding of government around small business as well, using substantive approaches, not procedural type approaches. So when there's breaches of procedure, not having that as the sort of centrepiece of dealing with a matter, but looking at the substance of matters. And then towards the end of there as well, we've got a whole lot of other ideas that probably do require legislative change. But for 2/3 of that paper, it's all about just changing the way we approach this system.
Okay, so anyone who's free now to answer. So what does this drop in EBAs and or no EBAs in place mean for businesses now?
Look, basically, from our viewpoint, it means that many businesses have less flexibility than they have had in the past. In our view, they have less control over engaging with their workforce to come up with a system that's going to simplify certainly their administrative load, enable it to be easy for them to remain compliant, and also design something that is going to work properly for their business and their projections over a period of time. So certainly when bargaining was working, it was great. And certainly businesses were very much engaged, but under the current regime, it just simply isn't working. And you know, not even for just up to your medium-sized businesses or your small businesses. Many of our national members or our larger players are terminating as well because it's not working for them. And part of that is about the fact that we do have consistent increases in awards. So we do see the minimum wage continue to increase year on year. In fact, the last one we've just had has been, I think, the highest since 2008. So whilst it continues to get that increase, it is going to be harder and harder to meet the better off overall test. So right now, you know, it's just simply not working.
And I would just add, I think the complexity involved in making an enterprise agreement means a lot of businesses don't bother and just sort of hope that they'll get away with what they're doing, which often isn't strictly compliant. And I don't mean that they're businesses that are setting out to rip people off or not do the right thing. They're trying their best in circumstances where it's a very complicated area, and they're putting in place arrangements that they think, well, hang on, this suits the employee and it suits us, and yeah, she'll be right because everyone's agreed. We've got a handshake on this. And it may be that what they're wanting to do could be achieved through an enterprise agreement, but the perception and the reality is that's too hard. So there's these more, not under the table in a sinister way, but less formal arrangements, which could get a lot of businesses into trouble if ever they, had a run-in with the Ombudsman. And again, I don't think that's because businesses are setting out to do the wrong thing. It's just that the mechanism by which they could do what they wish to do is too hard for them to follow.
I'll just jump in just for a moment on this as well, because you'll see one of the ideas that we've got down the tail end of this, which does require some change, is a tailored agreement for small businesses. I think there's a lot more that can be done inside the system that really will help small business, but the problems that small business often will approach, not having their own enterprise agreements, but having under the awards, will be multiple awards applying and the complexity of that. So trying to simplify the system so that small business can easily actually comply is what this paper and sort of what our office is advocating.
So that leads into another good question we've received from our audience. So if you do have any questions, feel free to put it in the app so I can see it. How do you approach a better off overall situation where the change is more subjective? So I guess that's mainly around the better off overall test. So for the agreement to go through, it needs to go through what we call the boot test. So how has that boot test changed?
Look, it's not necessarily that the boot test itself has changed, but certainly the case law around it now means that it's being read line for line, as was discussed before, with employee by employee, and that comes out of a Coles case that occurred very recently, where one employee actually decided to take on the union and Coles and won effectively. And that has just meant that because now this particular test is being read as black letter law, that again, you know, the flexibility is just simply not there in terms of creating these agreements. I mean, the thing is, if you've got a large workforce where we're talking thousands of employees, sometimes it can be very hard to assess whether there is one single employee that isn't better off overall. The other thing that this test doesn't take into account is what individual employees want to do. Certainly in our industry, which is quite a casualised workforce, we have a lot of students, you know, we have people that have multiple jobs that support themselves in retail. They may not want to work any other days other than Saturday and Sunday, right? So under the award, of course, they would attract penalty rates and things like that. Whereas if you are part of a business that has an enterprise agreement with fixed rates across your 7 days, those employees are going to be worse off, or they don't meet the better off overall test. And this is where, we've kind of come undone with so much red tape, because it's not taking into account what those individual workers want to do. And the fact is that we have a changing workforce.
I think also the question perhaps was alluding to more subjective benefits perhaps, and there's always that tension between, we're providing something that doesn't have a monetary value and we're taking away something that does have a monetary value, and how those things can be weighed up. And I don't think I can really provide you with an answer that says, well, look, this is precisely how you make that calculation. I think for the most part you almost have to disagree and not disregard a non-monetary benefit when you're making an assessment of your agreement. And certainly there's cases where agreements have fallen down because people have put in things like, we give an extra day compassionate leave, or we give paid parental leave. And yes, they are benefits and they're valuable benefits, but what percentage of your workforce will actually use those benefits, and what percentage of your workforce is missing out by you reducing the XYZ penalty, and really do they offset each other? And in a lot of cases, the Commission, particularly now, is just simply not prepared to find that that's adequate compensation. So I would say if anyone's negotiating agreements at the moment and you're trying to put a monetary value on an item that isn't a monetary benefit, you're probably better off not to take that approach at all.
I think this flows nicely into another question from our audience. So are we ever going to see an industrial relations legislative agenda turn back so that it is easier for startups and businesses to employ more people?
I can jump in and say, great question. That's what we're trying to do as our office, is get this on the agenda. When we started up the office, our office started back in 2016, one of the very first things we did was go out and talk to small businesses, to have a survey that people could tell us, what is it that's on your mind? This was number one, right up in the top 3 anyway, so it was right up the top, which is why we've given it such attention as well. So it's, for small business, critical that issues like what we've been talking about, as soon as you start talking about that, it's not going to happen in small business land. So you do need to actually really rethink the system to look after employees, but look after the small businesses as well. One of the really important parts of starting a business or growing your business is, do I take on an employee? If the answer is, I'm going to just keep the business, bootstrap it a bit so I don't have to do this because of all the red tape, we're really losing a trick there.
And look, it's certainly not just the Small Business Ombudsman that's fighting for this. In fact, many of our members are startups. We have a number of pure players and digitals that are just entering the market that may not have employees or who are thinking about employees. And it's something that we certainly bring to both sides of government as much as possible. 2 nights ago, I raised this particular issue with the Shadow Minister for Employment. Certainly Labor have come out with a particular view of the world in terms of, I guess, the Fair Work Act and how it would operate. And look, he certainly was receptive to the needs of small businesses and startups. That was about all he was receptive to. However, he was very quick to say that it had to be under the Labor lens, so whatever the party's view in particular circumstances would be. But if you have ideas, or if you are experiencing any issues as startups, it would be great to see your views go directly, certainly to the Shadow and certainly to the Minister for Employment, Craig Laundy, as well, who is also sympathetic to small business. But right now, we're not seeing any movement from government in terms of a willingness to make amendments to our current act. So I think if we do get any amendments, it will be if we get a change of government, and I'm not sure that they will necessarily be of benefit either.
And just to jump back here as well, amendments one thing, and you can get some fantastic advances through that, but if we can think about administration, which is often just as important, if we can do some good things there that mean that maybe amendments not as required, or when you do amendment, it's even better. That's sort of our approach. There's some good early steps, some wins to be had here.
And we just love them to spend some money on some of that administration. That would be wonderful.
Another question from our audience. These questions are good. For small businesses, why not use IFAs? So IFAs, that term is individual flexibility agreements. So under the modern award, there's something in it that says you can make an individual agreement with an employee.
I'll start. I'll give you my views on IFAs. I can probably count on the one hand the number of clients I have that use IFAs. Yes, small businesses could use IFAs. You just have to be really careful how you're using it. It's a mini enterprise agreement in a way. You still have to meet the better off overall test, and often what you'll find an IFA is aimed at is like a more of a preferred hours type of agreement. So I'm going to agree to work on weekends, and I'm going to agree to work all this overtime and not get any extra money because this is what suits me. Those agreements are sometimes looked upon with a little bit of scepticism as to really whether that passes the better off overall test. But what I would say one of the biggest mistakes businesses make, though, is they try and make an offer of employment conditional upon signing an individual flexibility agreement, which is unlawful. So you agree to take on a staff member going, well, I've got this IFA, I'm going to get them to sign, and you're following the law, so you don't offer it to them as part of their offer of employment. They come and start with you, they're entitled to the full kit and caboodle under the award, and then you present them with this IFA. Like, well, I don't necessarily want to sign this, and you go, oh, hang on, we've got everyone else on it, this is going to cause us quite a lot of an administrative burden. You find yourself in a situation where you don't really know what to do. So IFAs can be a valuable tool if they're used for the purpose that they were introduced, which is a genuine agreement between an employer and a single employee to reflect the needs of those two parties. And where you fall into trouble, I think, is when you take a cookie cutter approach and go, well, I've just got this IFA that I get all my casuals to sign so that I don't have to pay them weekend penalties, and they're happy for that because otherwise they wouldn't get the work. You can just get yourself into a bit of trouble. But certainly they're available, they can be used. I don't often advocate for them or recommend. Most of the times what my clients are wanting to do either can't be achieved through the IFA or could be achieved through a simple contract or agreement with the employee, and there's no need for the IFA, but maybe you have a different perspective.
No, I mean, that's definitely our approach. The majority of our members steer away from IFAs, maybe because they are administratively labour intensive. So if you have a large workforce or even a growing workforce, keeping track of all the different individual flexibility agreements that you've got with all of your employees is quite difficult. Also, we find that many employers don't apply them properly. So they tend to get themselves into trouble with those IFAs, and then we find we have to unravel them quite quickly. And also this cookie cutter approach really doesn't work. So I guess when you compare it to the IFA and the enterprise agreement, it's really, with the enterprise agreement, it applies to all of your workforce mostly. With an IFA, it causes problems because you've only got individuals on these agreements. Well, that's how it should work. So we certainly don't use them very often.
And I'll say the same thing again. It's not going to be that relevant for small business. So, again, the time and effort to do one of these things.
If you could click your fingers and change one thing about the industrial relations framework, what would it be and why, and what benefit would it have?
That's not me. Go for it.
I have a list. I do have a list. I'm just thinking, so which one? I am quite fond of our very first one, at the bottom of page 2. This is the idea of that. A tool that small business can simply enter their details into, get out of it, this is what I need to do, and when they do that, not then be in trouble for doing that. So have it operate as a safe harbour, which may mean they end up paying a bit more or providing better circumstances for employees, but it gives certainty. So the thing to remember with small business is that the person who owns the business, works in the business, is the person who does the tax returns at night over the kitchen table, right? So what a small business person is wanting to do is get that admin stuff done so that they can do what they do best, and that is sell their thing, their service, their good, whatever. And so the easier you can make all compliance, the better for small business.
I have had a brainwave. If I could snap my fingers and have one thing changed, it's not necessarily a change, but I'd have the modern award review process completed. I think, that's just been the most ridiculous process in history, valuable, and it will be very helpful once it's completed. But the fact that the 4-yearly review takes longer than 4 years to get done is somewhat farcical. I have to say, though, from the perspective of changing the law, I'm a lawyer. I deal with the law. I'm very familiar with the laws in this area. And from an early stage in my practice, though, I've always taken the view that the law is just the framework in which a business operates. It really should, the Fair Work Act or whatever piece of legislation should really be a very small part of the overall plan for your business and what's important or relevant to your business. And an employer who's setting out to do the right thing and treating their employees well generally shouldn't have too much concern over what is or isn't in the Fair Work Act. Of course, there's regard needs to be had for what's the wage rates that you need to pay and meeting your obligations under the awards, etc. But that's what we're talking about as an absolute bare minimum level of compliance. And from the Fair Work Act's perspective, yes, there's complexities in terms of making agreements, etc. But when you just look at what obligations does the Act place on your average employer, and what obligations does it place on your average employee, there's nothing, to be honest, that I have such significant issue over that I think a good employer would see as a hurdle, leaving aside some of the complexities about enterprise bargaining.
Look, I probably would want to see the Productivity Commission's recommendations around setting minimum wage implemented. So their recommendation is that basically it's removed from industry making submissions and it having basically a call made by the Commission on it to more of an economic body that looks at the current economic status of the country, takes into account all of the things that need to be taken into account when we look at wages. Right now, I don't think that particular issue is being given an informed approach as it needs to, because it has such a big impact, I think, on our business community and on industry's ability to grow. And when we have such a big push from global markets and from international players, it's certainly making it harder to keep business in Australia.
So I guess the general theme of this conference is workforce success. So as people who do work within employment law or relevant to employment law, how does Australia's industrial relations climate provide opportunities for employers and employees to work successfully together?
My wish list runs the other way.
Oh, look, I think there's definitely opportunities. It's about how you choose to do it, and look, certainly things that tend to offer around rostering and really looking at how you actually work with the award that you've got to deal with, or the multiple awards that you've got to deal with in the most productive and effective way, is the best way to get the most out of your workforce. I think the other thing is learning how to do things cleverly. So cutting your administration where you can, trying to work with the cloud, trying to have less paperwork, all of those kinds of things, and looking at other cost savings. Unfortunately, look, I think employees are an amazing asset where there are happy employees, and I think it's really important to look at kind of the culture of your business, having the number of employees that you genuinely need, and if you are looking to hire, looking for kind of what is the problem you're trying to solve as you grow and move forward, so that you don't grow too quickly and that you can still work within the framework that you currently have. It can be done. Some people do it very effectively, but I think right now we are in a little bit of a holding pattern in terms of labour laws enabling great success.
Having said I've got nothing to say, but a general sort of statement here is that, and it sort of runs off the back of what you're saying here, is that the people capital that Australia has is an advantage, I think, for Australia, but also the institutions, so the rule of law and the clarity and sometimes lack of clarity in various areas, but that is something that should not be underestimated as well. So that's what makes Australia a good spot for investment, and also is a great platform for Australian businesses going out as well.
And so I think, I'm not too sure how much time we've got left, but so since Australia's industrial relations system was federalised, we no longer have any competition between the states. So how competitive do you think our current industrial relations system is on the international stage?
I don't have a huge amount of insight into that, other than perhaps a bit of a tangent from a perspective of outsourcing and offshoring, which businesses related to my firm, we have a rather large offshoring business attached to us, and I work with a number of clients who offshore their work, and the difference between outsourcing and offshoring perhaps, or in my mind, and the way I use the terms, outsourcing is I've got a job, I don't want to do it, I don't want to be responsible for it, I'm going to give it to someone else and they're just going to send me the product. Offshoring is saying, well, I still want to have control over this work, I still want to be able to direct it, and it's a crucial part of my business, but I'm going to have that work done overseas as opposed to here in Australia. And certainly, the issue about wages in Australia and conditions mean that there's so many more types of work that businesses are finding they can have done in the Philippines, in India, even in Canada, that's cheaper than having it done here. And that's having a significant impact on the employment prospects of people in Australia. I don't think it's as dire as people... as the naysayers sort of cry out that all our jobs are going offshore, but certainly there is a lot of work going offshore, and we have to look at, well, what are the things, though, that still need to be done here? What are the skills that our people need? If we no longer need people to do data entry, etc. in Australia, well, let's not train people to do that. Let's train them to do something that we do need. So in a roundabout sort of way about competition and how we sit compared to other countries, I think there are a lot of safeguards in our legislation that don't exist in other countries, particularly in relation to workplace health and safety, and obviously also minimum terms and conditions. We are relatively in line with the likes of New Zealand, the UK, and some European countries, but there are European countries that are miles ahead of us in terms of what they offer staff, and we're obviously ahead of a lot of developing countries, as you would expect us to be. But from a competition perspective, I think that certainly in the last 10 years, this increase in offshoring of work is just the start of how that's going to impact our workforces going forward.
And I'll jump in as well, but it sort of hangs off the back, I think, of my last answer as well, and that is that our institutions do give us, I think, some real advantages here, but the work system is only one part of that whole economic system and legal system as well. So the competition going off and coming in, this is only one part of it, of what makes Australia a good spot for investment, or a good spot to launch out from. On competition, one spot where there is still competition in this sort of area is around payroll tax. And so you do find the states, and some smart ones, doing some really interesting things. Like you look at the ACT, they've basically set their threshold so that they're only capturing, I think, pretty much the banks, or anything big that is not the bank. There's not much else in Canberra apart from that, I think. But you do see a little bit of competition in this space there as well.
Oh, look, I think when you look at comparisons, it depends on how you want to compare the two, us to overseas. I mean, our workers are provided with safeguards, as they should be, so that they are treated appropriately. I guess the difficulty is probably the amount of red tape and probably the amount of complexity that is in our system. Certainly there are other Western countries that treat their workers appropriately, as we would want to see our workers treated, that aren't having the same difficulties in terms of compliance and an award system and just all of the things that comes along with the Fair Work Act. So look, I think there are some things that we do well, but there's definitely other things that we need to improve on.
So we've got 5 minutes remaining, but in terms of helping people now, so if there is a business who currently has an EBA or, say, for example, an IFA in place, what would you recommend as their course of action to check that everything's okay?
Me. This is something I've been on the bandwagon on for the last couple of years. I am a firm believer that businesses that have enterprise agreements really need to have a robust auditing system to be checking that their wages are in line. And I have a terrible story, really, in terms of one of my clients who, thankfully, I was not responsible for drafting their enterprise agreement, but they had 6 enterprise agreements across their workforce, 2,500 employees. Somehow they end up with 6 enterprise agreements. I mean, to me, that's just madness to start with. But these enterprise agreements all had a clause in them about how wages would be increased, and the business misinterpreted and misapplied those wage increase clauses from day dot. And when I've become involved with the business and said, hey, when did you last do an audit of wages, and let's have a bit of a look, because they got themselves into trouble with the Ombudsman for something else, I said, well, let's just make sure we're all tidied up everywhere else so we have no issues. $10 million in underpayment they had to make. We've been very lucky we haven't come to the attention of the Ombudsman in relation to paying back $10 million, but through a simple error in not understanding their own agreement that they had commissioned to be drafted. So if you have an enterprise agreement, I think one of the main things you need to be doing is regularly reviewing what you're actually doing against what your agreement says. Because in my experience, a number of businesses, particularly where you've got agreements that have been kicking around for years and they've expired, you may very well find that your practices have quite significantly changed from what the agreement says. Now, if employees are better off and they're getting paid more money and you're giving them more things than were in the agreement, that's fine. But what sometimes happens is you've decided, oh, we're not going to do that's in the agreement, we're going to do this instead. And again, are employees better off? Aren't they? So that's the first thing, is you need to be making sure that you're still regularly keeping a check on, is everything ticking along the way it's meant to be, and have our wages kept up with the award. But secondly, if you're at that point where you go, well, we've got this agreement, it's either coming up for renewal or we've got an expired agreement, rather than just either automatically renewing it, like perhaps you've done in the past, or for an expired agreement just sitting there going, oh, well, I don't need to do anything about that, I think it's really important for you to do that sort of comparative analysis to see where do your terms and conditions under your agreement sit compared to the award, or awards perhaps. And when you've done that analysis, you're able to see, oh, actually, you know what, we are getting a benefit from this agreement. That's great, let's keep it, or yep, let's renew it. Or you might see, well, we're actually getting no benefit from this agreement at all. We might be better off to either do nothing or look to terminate. And for businesses, though, who I do have a business in the retail industry who we put in place an enterprise agreement for them back in 2009, before the laws changed. And they were fortunate enough to put this agreement in at a time when they could strip out a lot of things and not necessarily have to fully compensate for the loss of entitlements. And with what's been happening in recent times with the trends of enterprise agreements being terminated by one employee putting their hand up and going, hey, I want this agreement terminated because it's so much less favourable than the award conditions, I've been encouraging that business for some years to say you really need to be prepared that could happen to you. So if you've got an enterprise agreement that's expired, you don't want the first time you've thought about what you would do in that situation to be when you get the Fair Work application and your notice of listing to come to a hearing. You want to know now what that looks like. How far behind the award are you? What is the real risk that someone might try and terminate your agreement? And if that happened, what would you need to do? What would your terms and conditions need to look like? What's the cost to the business? What's the impact on the business? So I don't think that... I think that this is an area where you do need to remain active, and particularly people who are just sitting on expired agreements need to really give some consideration as to what to do with those agreements. And sorry, I probably took up much more time, but I am quite passionate on that topic.
That's right. So final words, would you like a mic or from...
A little bit possibly on that question as well. And so thinking about employing businesses that are small businesses, I think the figures are something like half of the employing businesses have only up to 5 employees, something like that anyway. And so the sort of people we deal with as an office, and there's like, how many are we talking, depending on how you cut them, 3 million, can be quite small. And so to think about, you put yourself in the mindset of that small business, the person that they need to rely on probably closest is their accountant. And so it's not going to be the lawyer, the industrial relations lawyer or whatever. It's going to be getting close to your accountant and receiving that trusted advice regularly.
Provided you
Just
have a
on
good
that
accountant.
point, yeah.
So many of them get it wrong.
Yeah, and just to be aware, if there are any accountants in the room, they can now be joined if they get their advice wrong, if it can be proven that there was willful blindness and there's non-compliance. So, yes, stick closely to your accountant, but definitely find an expert in the area because it is too complex to rely on uneducated advice. So whether that's through an industry body or, a lawyer who practices in industrial relations, because I always say it's like brain surgery. You don't get somebody who specialises in podiatry to operate on your brain. It's exactly the same when you're getting advice about law. You've got to find a specialist. So we see too much non-compliance. I mean, right now, I think even in our industry, the statistics are around 40% of businesses are non-compliant, and it's not because they want to be non-compliant, it's because it's complex, it's hard. So, look, I would certainly say, number one, make sure that whoever you are getting advice for is absolutely an expert and knows what they're talking about. Continue to review your processes and your agreements and your contracts and your arrangements with your employees periodically, especially with the increases that come through. And if you do find a problem, make sure you deal with it as quickly as possible. Don't ignore it. Or put it away or think it'll go away. It won't, it'll just grow. So make sure you deal with it as quickly as possible.
I think that's time's up and lunch is happening downstairs, so I'm sure everyone wants to eat. Thank you everyone for coming.